All right, now we're going through Chapter 4, Interviewing and Report Writing. Unit 1, Lesson 1, Taking Good Notes. Why take notes? Note-taking is the process of writing down information concerning an incident, event, activity, or statement. When responding to a call, you will need to gather preliminary information from a complainant, witness, victim, or other person of interest. Basic questions of where, when, who, what, how, and why you should answer in your notes. Where documents the location of the incident as well as the location of people and items involved. The where is a legal requirement that verifies the jurisdiction. When documents the date and time of an incident occurred. The when of an incident is a legal requirement regarding the statute of limitation and the right to a speedy trial. Who lists and describes everyone who may have information about what have happened or who was involved in an incident. Describing who requires documenting more than a person's name. Capture information such as name, address, telephone numbers, age, date of birth, employment information, race, and sex of each person in your notes. What describes the information regarding the nature of an incident. As you describe the what element of an incident, consider questions such as what happened and to what, or to whom. How specifies how an incident occurred. Explain the action of event as well as how different objects were used. Make sure to document your actual observations and not merely your conclusions. The why describes the reason for an incident and is sometimes called the motive. What actions did you take describes the actions officers have taken during the investigation. Make sure to note under spelling that not every individual will be listed in these databases, such as, David, FCIC, NCIC. When it comes to abbreviations, some good abbreviations are WHF, that would be white, Hispanic, or female, and then B or M would be like black and male. Reviewing your notes. Reviewing your notes before leaving the scene is imperative. The accuracy of your report will depend on having good fundamental notes. Make sure to be familiar with your agency policies before disposing of your notes. Lesson 2, Preparing for the Interview. What is an interview? An interview is a conversation with a person who has knowledge of an event or individual. It is not an arrest situation, and the person is free to leave. A statement is a person's permanent record, oral or written, that explains an incident. An oath is a solemn and formal promise, often invoking God as a witness to tell the truth regarding what one says or intends to do. An affirmation is a solemn and formal declaration in place of an oath, usually taken to avoid the religious implications of an oath. So remember, the oath is religious. Affirmation is the formal declaration in place of that oath. Preparing techniques. The pre-interview process involves planning who to interview and for what purpose. You will also determine where you will conduct the interview. Interviewee considerations. The Florida statutes require that an interviewee with autism has the right to request that a mental health or other related professional is present at all interviews. The interviewee's parent or guardian has the right to make this request on behalf of the interviewee. Your order of interviews. You have 6 categories: a complainant, a victim, a witness, a source, suspect, or other person who may have knowledge about the incident or people involved. Generally, you will interview the complainant or the victim first, followed by witnesses. Typically, the suspect is the last person you interview. You may want to interview witnesses who are more likely to cooperate first. Preparing questions. Open-ended questions encourage conversation and require the interviewee to think. Make sure to avoid asking leading questions. Leading questions steer a person's responses to a specific conclusion. Timing and location of the interview. Try to conduct interviews immediately or soon after an incident and when possible at the scene. You may have to conduct an interview at a later time, such as when the scene is too hectic, there are too many distractions, or when an interviewee has been injured. In such cases, it may be preferable to conduct the interview at your agency station or medical facility. The proper time to interview will depend on various factors, including the physical condition and emotional state of the interviewee. It is best to conduct interviews in person. Whenever possible, interview each person in isolation. When you isolate the interviewee, it creates a sense of privacy. All right, Lesson 3, Conducting the Interview. A planned interview has 3 stages: warm-up, primary, and closing. During the warm-up stage, you will establish rapport and build an understanding with the interviewee. Using procedural justice when interviewing someone can make them more likely to cooperate. During the primary stage, you will get information about the incident from the interviewee. During the closing stage, you will conclude the interview. Do not make threats, promise leniency, or create physical evidence for use during an interview. Using these tactics during an interview may cause admissions, confessions, and evidence to be suppressed. It may also result in disciplinary action and civil liability for you and your agency. So again, don't make threats, don't promise leniency, and don't create physical evidence during an interview. Basic interview techniques. Mirroring. Mirroring is appropriately matching another person's speech patterns, gestures, body language, mannerisms, or posture. Minimal encouragers. These are brief statements that indicate that you heard what the interviewee said and want to hear more. This can include nonverbal encouragers, such as nodding your head. Examples of verbal encouragers include okay, go on, then what, and tell me more about that. Cognitive interviewing. Make sure, on a side note, do not use cognitive interviewing on victims of sexual assault. Cognitive interviewing tries to recreate the event, either physically or psychologically, to enhance memory recall. Interviewing victims. So, for the sexual offense victims, use a trauma-informed approach. Trauma-informed approach is used to interview... Trauma-informed approach to interviewing includes maintaining a demeanor that is reassuring, empathetic, and non-judgmental. A traumatic event can distort the victim's perspective of time and distance. Remember, with sexual offense victims, use a trauma-informed approach and not cognitive interviewing. A trauma-informed approach can be helpful with any victim, but is highly recommended for victims of sexual offense. This approach should be used in conjunction with a culturally sensitive response as described in Chapter 2. Now we're talking about behavior and response. You should also observe the behavior of the people you interview. At the outset of the interview, ask biographical questions that will not produce stress or a deceptive response, such as the interviewee's name, date of birth, address, place of employment, and recent activities. Make sure to pay attention to verbal and nonverbal responses to understand their body language. Recognizing deception is a valuable skill. Some signs of nervousness, stress, and possible deception may include physiological, behavioral, body reactions. So physiological is stuff that has to do with your body doing something. So that's increased perspiration, changes in skin color, dry mouth, observable increase in pulse rate, observable change in breathing rate. Now, with behavioral characteristics, that is something that the person is doing. So pausing or silence, foot tapping, leg shaking, finger tapping, pacing, not sitting still, refusing to look at the interviewer, giving answers that appear rehearsed, verbal responses that are inconsistent with nonverbal responses, attempting to change the line of questioning, overly eager to help, things like that, looking for an escape route. So that's behavior, where physiological is like sweating and dry mouth and your pulse changing. Oaths and sworn statements. When an interviewee makes a sworn statement, they may provide written or oral facts under oath or with a penalty of perjury. The Florida statutes give you the authority to administer oaths while performing your official duties. However, this does not certify you as a notary. Florida law allows a person to make an affirmation instead of an oath. So just remember that you're not a notary, but you are able to, you have the authority to administer oaths while in your official duties. The law does not require a person to raise their right hand when giving an oath or affirmation. That is just for the effect. When you're dealing with written statements, some guidelines that you may consider: you may ask questions or have the interviewee relay the information in their own words while you write the statement. Do not paraphrase or summarize the statements from the interviewee when you write down for people. Under certain circumstances, it may be impossible to take a statement. Always document why a person did not provide a statement. For example, a person who is injured and requires immediate medical attention is often unable to give a statement at the scene. You cannot force someone to provide a statement. However, they could be subpoenaed and required to appear in court. Signing statements. When an interviewee submits a written statement, you will need to read it to verify that it is complete and legible before they sign the document. Make sure at the end of the document you end it with a written statement with the following phrase: dictated by blank and written by officer blank. Electronic statements. One disadvantage is that some words or descriptions may not be clear, which can lead to misunderstanding the information. Make sure to explain to the interviewee that you're recording the interview. On the recording, make sure to state the following: your name, names of people present, your location, date and time, incident to be discussed, the case number, and the type of incident. When conducting a recorded interview, if you have to suspend or pause the interview, document the following before resuming: the reason for the suspension, that you are continuing the statement recording and include the date and time, and that you did not ask the interview any questions while the recording was suspended or paused. Make sure at the end of a recording you state the following: this now concludes a statement of so-and-so regarding incident blank, case number blank, the time is now blank. Then we move on to Miranda and laws of interrogation. An interrogation consists of questioning initiated by law enforcement that is directly or indirectly intended to elicit an incriminating response. An interrogation is different from an interview because the person being questioned has been detained and is no longer free to leave. So remember, with interrogation, you have custody. With Miranda, you have custody plus interrogation. So with interrogation, the person is not free to leave. The Miranda decision. Miranda v. Arizona. The Miranda decision puts the burden of explaining Fifth and Sixth Amendment rights on the law enforcement officer. If you fail to follow the rules set forth in Miranda, any statement or admission obtained from the interrogation cannot be used in court. And there are 4 elements to the Miranda decision: custody, interrogation, understanding, and free and voluntary waiver of rights. So custody. Custody means a person is deprived of freedom in a significant way. Generally, interviews at the scene, such as Terry stops, traffic stops, and roadside driving under the influence test, the UI tests, are not considered custody because they are typically brief in nature. So again, Terry stops, traffic stops, and DUIs are not custody. Handcuffing a person or otherwise restricting their movement so that they are not free to leave is considered custody. For the purpose of Miranda, the court asks 2 questions. 1, what were the facts and circumstances surrounding the interrogation? And 2, given those circumstances, would a reasonable person have felt they were not at liberty to end their interrogation and leave? Then we move on to Ramirez v. State. The court ruled that the determination of whether a reasonable person in the suspect's position would consider himself in custody for the purposes of Miranda. Note that when there are multiple officers present or emergency lights activated, it can create an environment in which a reasonable person might believe they are not free to leave. During interrogation, officers may use direct or indirect questioning. Often, a suspect who is in custody will voluntarily give information, even when not solicited through questioning. These are known as spontaneous statements and are admissible, even if the officer did not advise the suspect of their Miranda rights. So if you're transporting somebody, you didn't read Miranda, and all of a sudden they start talking, these are spontaneous statements, and they are allowed in court. Basic questions posed to a suspect, such as biographical data, date of birth, name, address, things like that, are not subject to Miranda rules. Waiver of rights. Once you have advised the suspect of their Miranda rights, you are required to provide a waiver before questioning may begin. A waiver can be written or even implied. Invocation of rights. If a suspect makes a clear and unmistakable request to invoke any of their rights under Miranda, all questioning must cease immediately. So if the question says, Officer Tom goes to, question a suspect and he reads a Miranda and the person, they invoke any of their rights, what do? The answer is you just immediately stop asking any questions. If the suspect invokes only their rights remain silent, you may reinitiate the interrogation after a significant lapse of time. If the suspect requests an attorney, you are not allowed more questioning unless the suspect's attorney is present or the suspect reinitiates communications. However, if they do reinitiate, you would have to read an entire new Miranda rights. Simply reminding the suspect of their Miranda rights is insufficient. So again, like I said, you would have to reread them new Miranda rights. You may reinitiate contact with the suspect if they experience a break in police custody of at least 14 days. So if they have their right to an attorney and it's been 14 days, you are allowed to read the Miranda and ask them questions again and see if they'll speak to you. The right to have an attorney present contained in the Miranda warnings is crime specific. So you can't, therefore you may not question the suspect about a burglary when the suspect was arrested on completely unrelated charges. Juvenile interrogations. The standards for questioning juvenile are the same as for the adults. There is no statutory requirement for the parent or guardian's consent before you may interrogate a child. So you're allowed to interrogate them without parents or guardian's consent. However, the statutes require that you make a reasonable effort to contact the parents or guardians when you take a juvenile into custody. So maybe you try calling the parents 3 or 4 times. I would think that would be reasonable, trying to contact them. All right, the Miranda warning applies to juveniles. A waiver of juvenile Miranda rights will be closely scrutinized by the court. Factors that the court will consider in determining if a juvenile understands their rights and the significance of waiving those rights include the juvenile's age, marital status, education, intellectual level, and experience in the criminal justice system. Juvenile interrogations may only last for a reasonable length of time. If the child is held for any length of time before the interrogation, note the length of the delay and any responses and any reasons for the delay. Keep in mind that there is a limit to the number of times you can interview a child. There is no number, but just keep that in mind. All right, Unit 2, Lesson 1, reports. A report is a written document that gives information about an event, situation, occurrence, or incident. Your agency may refer to this type of report as an offense or offense incident report. A well-written report does three things. 1, it aids the state attorney's office in prosecutions. 2, reduces legal liability for you and your agency. And 3, saves your agency time and experience. Reader considerations. Each reader would develop an opinion about the writer based solely on the content or makeup of the report. For example, prosecuting attorneys will make crucial decisions about a case based on what they read in the report. On the other hand, defense attorneys will seek to exploit any weaknesses they see in the same report, and both will make assumptions about your competence. A report is professional. A report is a professional document and should be businesslike and objective. Report only facts that you learned, not your opinions, and make sure to use plain English. All right, Unit 2, Lesson 2, Mechanics. Grammar, punctuation, and spelling are just as important as the report's content. Good vocabulary. When you expand your vocabulary, you will increase your report writing skills. In addition, you will become more effective at precisely describing things that you are required to document. Proper grammar. Grammar involves the rules and guidelines that governs a language usage. I guess I'll go quickly through the noun, pronoun, verb, adverb, adjective, preposition, and conjunction. So we obviously know what a noun is. A pronoun is an act as a substitute for a noun. So they stopped the car, he ran from them. So that would be they, he, and them. So you're replacing the noun. We all know what a verb is. That's the action. So he ran, he jogged, he flew, things like that. Adverb, it describes, identifies, or quantifies a verb or adjective. So the subject ran quickly. Quickly is the adverb there because it describes how he ran. He became extremely exhausted. Extremely describes how exhausted you were. So that's an adverb. We obviously know an adjective that describes something. A preposition. A preposition links words and phrases and provides temporal, spatial, and logical relationships. So the subject jumped out of the car, went over the retaining wall, and ran into the store. So it kind of provides, like it says, spatial, temporal, and logical relationships. So you jump out of the car, you went over the wall, and into the store. Those are all prepositions there. Then you have conjunctions. Those when you connect words or phrases or clauses. So Officer Russ and I approached the car. Obviously, the conjunction is and because you're combining the two. I covered the car while he contacted the subject. So while kind of connects those two sentences there. A sentence is a group of words that contains a subject, a verb, and usually an object, and that expresses a complete thought. A singular subject should have a singular verb, and a plural subject should have a plural verb. A sentence fragment is a group of words that lacks a subject, verb, or object when one is needed, or fails to express a complete thought. Point of view, voice, and tense. Point of view. Write reports in the first or third person, depending on your agency policies. Most reports are in the first person. So first person is I saw, I spoke, I arrived. Third person is the officer saw, the officer spoke, the officer arrived. Voice. Write your reports in active rather than passive voice. In active voice, the subject of the sentence comes before the verb and is clearly stated. So just because Liverpool reminded me or mentioned a really good way to know the difference between the two. So when a sentence is passive, you'll use the word by. So, for example, John was struck with a frying pan by Anne, and that's bad. So if you see the word by, every single time you see the word by, that is a passive and not an active sentence. So, for example, Anne struck John with a frying pan. That's how you're supposed to write. That's active. When you see the by word in there, you know it's passive. That's John was struck with a frying pan by Anne. Then we do tense. Most law enforcement reports are written in past tense because the events have already occurred. Make sure when writing, you use the spell check feature. And you can also use a dictionary to check your spellings. Make sure to capitalize the names of people, streets, cities, and states. Capitalize the names of specific organizations and buildings. Capitalize holidays, days, and months. Capitalize geographical locations, such as the South would be capitalized. Capitalize titles of professionals only when names are used. So you wouldn't capitalize chief, but you capitalize Chief Sunanan, right? Capitalize brand names. Then we move on to proper punctuation. There are 7 coordinating conjunctions: for, and, nor, but, or, yet, and so. Make sure to use a comma after an introductory clause. A clause is a group of words with a subject and verb that tells the reader what the sentence is about. So, for example, when the alarm sounded, the burglar ran from the store. So the object of the sentence is the fact that the burglar ran from the store. But when the alarm sounded is the clause, an introductory clause. So you would put a comma, when the alarm sounded, comma, the burglar ran from the store. Use a comma to separate items in a series of 3 or more. Use a comma to separate non-essential phrases in a sentence. A phrase is a group of words that forms a grammatical unit. So the difference between a clause and a phrase is a group of words with a subject and a verb and tells the reader what the sentence is about. A phrase is a group of words that forms a grammatical unit, though it is not necessarily a complete sentence. So an example of a phrase would be, which I found on the window. The fingerprints, which I found on the window, belong to the victim. So which I found on the window is a phrase. Then we move on. Use a comma between 2 or more adjectives when they separately describe the same noun. So the inmate used a small, comma, sharp object to cut his own arm. So there are 2 different types of adjectives here. They separately describe the same noun. So a good example of that would be, he threw the white toaster oven at me. You wouldn't say he threw the toaster white oven at me. So make sure do not place a comma between 2 or more adjectives when the adjectives before the noun changes what the noun is. One way you can test this is if you reverse the adjectives, they do not make sense. So instead of saying the white toaster oven, you can't say the toaster white oven. So when they go together, you don't use any commas. But when you're using an adjective to describe the same thing, so let's just say a long, furry pillow, right? You would put a comma between those because they describe the same thing. But if you're saying a white toaster oven, white and toaster do not describe the same thing, so you wouldn't use commas on that. Use a comma to introduce a quote. So when I arrested her, comma, she said, comma, and then your quote, I'm going to burn this house down. Use commas when writing dates and addresses. So, for example, the first robbery occurred on January 12th, comma, 2018, comma, at this street. The only time you would use a contraction in a report is when you document a direct quote. So that's the only time that you'll use a contraction, which a contraction is when you say do not, but instead you say don't with a comma, D-O-N, comma, T. That's a contraction. You're not supposed to use those unless you're doing a direct quote, when someone used those in a quote. All right, Unit 2, Lesson 3, Elements and Principles of Effective Report Writing. Organize information. You can organize information in the following 2 ways: by order of events or by category. So order of events is chronologically. By category, that would be like all your witness statements, then you'd have another paragraph for your victim statements, then another paragraph for your suspects, your weapons, the elements, etc. Elements of an effective report. The largest and most important part of a report is the narrative. A narrative is a detailed account of an incident and events related to the incident. Normally, narratives are written in complete sentences detailing a sequence of events. The format is the way information is organized and presented in the report. Your report should present the material aspects of the case and the actions of the subjects, such as who are you with, who was involved, who do you think did it. Factuality. A report must be factual. Do not include your personal opinions, judgment, hunches, or guesses in a report. Make sure to omit unnecessary reports and irrelevant material. Remember that a well-written report shows that you are professional and competent. A well-written report can be your greatest strength in court. If you write the report poorly, the defense may try to discredit it. And make sure to use plain and straightforward language. And always prepare reports using standard English. Jargon. Jargon is vocabulary used in a profession that has meaning only to the people who work in that particular field or profession. For example, I got your 6, smash and grab, signal 0, things like that. Slang consists of informal, non-standard words often used by regional or specific groups. Do not use slang in a report. So remember, jargon is the profession, where slang is just, slang words that are based on the region you live in. Text speak comes from text messages and digital communication. It consists of abbreviations, acronyms, or initials, so LOL, IDK, things like that. Always remember that the report you prepare will become public record. If a witness, victim, or suspect uses jargon, slang, racial slurs, or offensive language, report their exact words using quotation marks. These statements can be valuable to the investigation and point out a person's frame of mind. Make sure when writing reports, if you do actually write them out, use a black or dark blue ballpoint pen. Timeliness. After you complete a report, Turn it in by the end of your shift and let your agency policies state otherwise. If you need to conduct further investigations, you may have to write a supplemental report. All right, introductory, body, and conclusion. The introduction of a report usually includes the date and time, the location, your assignment and arrival time, your name, identity of the victim, suspect, and complainant, and your initial actions. The conclusion explains how you resolved the situation. It also describes how you handled the information you obtained. It includes any citations you issued or any arrests you made, and it documents appropriate criminal charges. And the body is obviously the narrative with your detailed account of your events. The content of the narrative should answer the following 4 key questions. Why were you there? What did you observe? What did you do? And what were the outcomes? Before writing the affidavit narrative, make sure to review witness statements, incident or supplemental reports, and evidence. A probable cause affidavit must contain a description of the offense with sufficient facts to show the probable cause of each element of the charged offense. Some of the facts in the affidavit could include the date, time, place, city, offense charge, the correct Florida statute section number, reason for the contact, any other information necessary, name of the victim, name, address, identifying information, any statements by the suspect, name, address of all the parties present, if and why a search occurred. Another officer, a notary, a deputy clerk, or a clerk of the court who administered the oath to the arresting officer must also sign as required by the law. All right, we got one lesson here left. To evaluate a report for errors, consider spelling, grammar, punctuation, capitalization, vocabulary, and typographical errors. And that completes Chapter 4.